On May 5th, 2025, the Department of Education is resuming collection activities against people with defaulted student loans. But you're not going to wake up on May 5th to a wage garnishment because that's not how it works. Here's what to expect if you're in default. And remember, if you're in forbearance, that's not default. If you're in deferment, that's not default. If you're in an IDR plan with a $0 payment, that's not default. And if you're past due by less than 270 days, that's not default. If you're getting letters from a collection agency or directly from the U.S. Department of Education instead of your regular servicer, chances are you're in default. When borrowers default on federal student loans, the government can administratively garnish up to 15% of your disposable income without a court order. That's called Administrative Wage Garnishment, or AWG. And AWG for federal student loans is governed by federal regulations. There's a process that the government is legally required to follow. Before garnishment begins, borrowers must receive a 30-day notice explaining the department's intention to garnish wages, the nature and amount of the debt, and their rights to inspect records and object to the garnishment. You also have the right to request a hearing to challenge the garnishment based on various grounds, including financial hardship. If you request a hearing within 30 days of the date of the notice, the garnishment is postponed until the hearing is completed. Entering rehabilitation for your defaulted student loans will also prevent garnishment, and so will submitting a consolidation application. So if you're in default on your federal student loans, a wage garnishment won't just appear on your paycheck. There's a process, and that process can take some time that you can use to take action to prevent the AWG from starting in the first place. Need help with your federal student loans, your private student loans, or any debt whatsoever? As always, you know where to find me.